I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame. Today, your boy TP is bringing you compilation number 234. And for this compilation, we will be staying in the state of Michigan for these three judges that will be featured here on the compilation. Don't forget to like, comment, share, and subscribe. Commentary will be left in some of these proceedings. Chapters will be added for your convenience. And now for the best part, the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge David Robinson. Second, we will be in the courtroom of Judge Victoria Shackelford. And last but not least, we will be in the courtroom of Judge Julie LaCoste. And remember, these judges are all out of the state of Michigan. Listen, no need to prolong this. Let's go ahead and jump into 234.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyway. So.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
Mr. Hurst. I'm not going to have this.
Your Honor, she cut
I'm
me
not
off.
going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can't finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst?
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding to Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so The understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
discovery. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written requests for discovery, you have a right to do that too. You can send written interrogatories, requests for production of documents, and requests for admissions, same as her. All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Yeah.
if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side. All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? The plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of general issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
Well, guys, we have come to the end of another proceeding. And as we can see earlier on in this proceeding, Mr. Kevin Hurst truly rubbed Judge Robinson the wrong way, to the point of where Judge Robinson blurted out, "This is not a clown show. We're not having this. I'm not going to allow you to do this in my court. Whether we're on Zoom or whether you're in person, it doesn't matter. I'm not going to have this." And as we can see, Kevin Hurst, he wanted to represent himself, but did not even have enough understanding to receive the discovery packet. Instead, he refused it, thinking that he was benefiting himself when actually he was shooting himself in the foot. But let's give Judge Robinson credit, because later on he gives him an opportunity to receive the packet again when he did not have to, even though Mr. Hurst rubbed Judge Robinson the wrong way in so many different ways. We see where Mr. Hurst, he goes on this crazy rant about how the prosecutor cut him off. She's not allowing him to talk. But if you go back in the moment when he said that in that part of the proceeding, he actually has stopped talking. So just every which way he turned, he wasn't doing himself any type of favors. We see, just like in the Marcus Campbell situation, if you have not seen that, I don't want to spoil everything that went on in there, but they asked for a summary disposition and it was granted. And we went over a little bit of what a summary disposition was in the last case, and that is also known as a summary judgment, where it allows the judge to rule in the favor of one party without going, through a full trial if the other party didn't dispute the facts clearly and in the right manner. And as we can see in this situation, he definitely did not dispute anything that these lawyers that were representing these banks had to say. So with that being said, guys, I know you guys are ready to get out of here and do what you got to do. I know you're anxious for the next proceeding, and God willing, Lord willing, we will have another one for you tomorrow. So with that being said, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. See you guys soon. God bless.
All right, Mr. Page, this is 242804, the City of Taylor versus Zachary Page.
And good afternoon, Your Honor. For the record, Matthew Sick for the people.
Okay, and I have a note on here. The people are requesting the case be set for a jury trial, and the defendant wants to fire the MIDC attorney. Is that accurate? Mr. Page, are you asking to represent yourself?
Yes, Your Honor. I'm representing myself.
Okay. Okay, you have a right to represent yourself, but I want to make sure you understand this, Mr. Page. You have a right to do that, okay? But you understand that attorneys go to law school and they study the rules of evidence. And if a person who is not a lawyer wants to proceed in a case, they're held to the same standard. You have to play within the same rules as a lawyer when you represent yourself. Do you understand that?
Yes, ma'am.
Okay, Mr. Page, I want you to see this. This is the Michigan court rules. This book is the rules that govern how we do trials, how evidence is admitted, how questions are asked, how trials proceed. And I'm going to assume you've not studied that book. Do you understand that if you go to trial and you represent yourself, that you will be held to the same standard and will be required to comply with those rules?
I understand.
Okay, is there anything else you want to put on record?
Yes.
All right, go ahead.
I, Zachary Page, lowercase AHARY, a living man and one of the people of the Constitutional Republic of Michigan, appearing today, sui juris. I am here under special appearance and under duress to address this matter. I am the beneficiary of the trust established by the U.S. Constitution and the Michigan Constitution, which operate as trust agreements. Under these trust agreements, public officials act as trustees and are bound by their oaths of office to serve the people, the beneficiaries. Their primary duty is to uphold and protect the inherent and unalienable rights of the people as mandated by these constitutions.
Okay, all right, Mr. Page.
I have more.
I know you can submit it in writing. I've heard it all before, sir. If you want to be a sovereign citizen today, that's fine with me. All right, but we're going to get through this court proceeding, and I want you to know you're going to behave at trial. You are bound by the laws of the state of Michigan, and that's how we'll be proceeding. So, sir, as to arraignment, how do you plead? You can plead guilty, you can plead not guilty, or you can stand mute.
Could you repeat the last part, please?
You could stand mute. That means you don't say anything and I enter a not guilty plea for you. So a guilty, not guilty, or stand mute.
I'm pleading not guilty to this.
Okay, I'll enter a not guilty plea on your behalf. Sir, I have to go over a few things with you to make sure you understand them, okay? You're charged with interference with police authority. There is an allegation that on November 4th of 2024, while traveling southbound Telegraph near Brest Street in the city of Taylor, that you engaged in behavior that obstructed or interfered with police authority. That is the allegation against you. This is a misdemeanor. It is punishable maximum by up to 90 days in jail and a fine of up to $500. Sir, you have the right under the Constitution to have a trial by a jury and to have the assistance of an attorney. And you have a right to an attorney appointed at public expense if you are indigent, meaning you don't have the money to pay for an attorney. And if the offense requires a minimum jail sentence, there is no minimum jail sentence on this case, or the court determines it might sentence you to jail. It's my understanding that you have waived your right to a court-appointed attorney. You've already put that on record and you intend on representing yourself. You also have a right to a trial. And at that trial, you have the following rights: to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Those are your rights under the United States and Michigan Constitution. Do you understand what I just read to you, sir?
Yeah.
I'm not asking if you agree. I'm asking if you understand. And is that a yes?
Yeah, I understand.
And we have a charge of speeding of 11 to 15 over. Do you understand that?
Yes.
All right. Has an offer been made on that, Mr. Zick?
No discussions have, no discussions have been.
And we have a charge of speeding of 11 to, sorry, go ahead. No discussions.
No discussions.
Would you like to have discussions with him regarding that civil infraction?
Yeah, I would like it dropped.
Okay. Well, I don't know that he's doing that, but he might offer you a reduced ticket with no points. I mean, I don't know that he will. I don't know what he'll offer you, but there could be a reduction. Do you want to discuss that possibility with Mr. Zick?
Yes, I'd like to.
Okay, I'll let the two of you discuss that.
Thank
And I did receive your filing. I'm reviewing it now.
Okay.
And so if that's what you're intending to put on record, it is officially part of the court file. So
Okay.
we don't need to do it orally because it's part of the file.
All right.
Okay? All right, I'll let you two talk and I'll see you back in just a few minutes.
Thank you.
All right, we're back on record. Were you two able to have discussions?
We had the discussion, Your Honor, but we're unable to reach a resolution.
Okay, so was an offer made?
Yes.
Okay, can you just tell me what the offer
Oh,
was?
yes, Your Honor. The people offered to reduce the charge of speeding 11 to 15 over to a double parking.
All right, and Mr. Page, you understand that's a civil infraction, has a fine of 165, but it doesn't have any points on your license.
Right.
Okay, and you've rejected that offer?
I have.
Okay. All right, so we're proceeding with our hearing then.
Thank you.
Mr. Page, is there something you want to, if you're just going to read me a giant sovereign citizen objection to my jurisdiction, I'll give you 2 minutes to put whatever you want to put on record, and then we're proceeding with the hearing. Fair?
Don't I have the right to be heard lawfully?
Well, you have the right to ask
2
questions
minutes.
to the witness
Okay.
and to, make any arguments you want to the court.
Right. I
But
understand
as
that.
far as jurisdictional arguments, the court does have jurisdiction.
Okay, is this court operating in administrative or judicial law?
I'm not participating in this, sir.
Well, I would.
Well,
have
you
to- I
know,
would
this
have
is
to
a court
know.
of law.
I would have to know because there's no injured party in this case. So
There doesn't
if
have to be.
There does. In order to set bond against me, there has to be an injured party.
Okay. Anything else? I am operating under the laws of the state of Michigan and the Michigan Constitution. And that's the information that I'm willing to provide. And
Okay.
and I'm certain you're aware of that, sir. You've lived in the United States for your life.
And I'm also aware that I have the right to freely travel at my own vehicle
Correct.
that I maintain and take care of. There was no injured party. I was not engaged in commerce or commercial activity.
Okay, well, they can get tickets too for speeding.
I'm protected under the Constitution. Speed limit's not law. The Constitution says that.
Actually,
The speed limit
The
is a statute,
state's-
code, and ordinance.
correct. Statute and ordinance, that's
Yeah.
correct.
So how could I be charged if we're operating under this type of law and no injured party? This-
Well, your
this matter-
federal right to travel under the or the federal constitution doesn't mean that you're not subject to regulatory. I mean, do we not have to get driver's licenses? Do we not have to get car insurance? Do we not have to follow basic speed laws? I mean, you can have a constitutional right with limits and, or regulatory provisions or statutory provisions. The right to drive is not written in the Constitution. The right to travel is.
Yeah, and I made that clear to the officer that I was traveling. I wasn't driving. I had that.
Were you in a
I had
car?
that on film too.
So were you in a car?
Yes, I was.
All right, you were operating a motor vehicle. And were you in the city of Taylor?
Yes,
Okay. All right.
I wasn't operating a motor vehicle though. I was traveling freely down the road.
In a motor vehicle.
That I maintain and take care of myself. That's my property.
Okay. I understand that. That doesn't affect this. Okay, I mean, you were driving a car in the city of Taylor.
Uh-huh,
Yes. Okay. And that's why we're here.
okay.
Okay.
Your Honor, people would waive opening at this time would be prepared to call their first witness when you're ready.
Okay, call your first witness.
Thank you, Your Honor. At this time, we call Corporal Billy Schillenberg to the stand.
Okay, officer, if you can come on up to the witness stand. Raise your right hand when you get up here. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay, have a seat. Mr. Zick, your witness.
Thank you. Corporal Schillenberg, can you state your name and badge number for the record?
Corporal Billy Schillenberg, badge number 260.
And you're employed with the Taylor Police Department?
I am.
And what's your position with the police department?
My rank is a corporal in the traffic bureau.
And Mr. Schillenberg, were you working back on November 4th of 2024 in the afternoon hours?
I was.
All right. I'm going to direct your attention back to that date and time. Can you describe to the court where you were approximately doing traffic detail on November 4th, 2024 at about 1:35 p.m. At that time?
On November 4th, 2024, approximately 1:49 p.m. I, Corporal Schillenberg, I was sitting stationary and
Sir, you can't read off your report. You can use it if you want to use it to refresh your memory. You're free to read it, but you can't just read the report into the record.
I, Corporal Schillenberg, was sitting stationary, monitoring traffic on southbound Telegraph, south of Brust Road, when I observed a silver Ford Fusion traveling faster than the vehicles around it, which time I activated my LiDAR device, which I am trained and certified to use in the state of Michigan. Pointed the LiDAR directly at the hood of Mr. Page's vehicle and received a reading of 58 miles per hour in a 45 mile per hour zone at 694.5 feet.
Wait, say that again. 58 miles per hour. No, what was the speed limit there?
45.
And Corporal Schillenberg, this all occurred in the city of Taylor, County of Wayne, state of Michigan?
Yes, sir.
All right. And you indicated you're certified with the LiDAR device. Can you briefly explain how that works and what does it mean when you got a reading at 694.6 feet?
So the LiDAR device, in order to operate it, you have to go through a training class to be certified to use it. When you activate or turn on the LiDAR device, it has to go through a self-inspection, and it has to pass all of these self-inspections for it to work. On that particular day, I did my self-inspection of the device, powered it on, it did pass all tests. So the way the LiDAR works is when you point the LiDAR at the hood of the vehicle, it'll give you a speed reading and a feet reading. So the feet is the distance away from where the LiDAR is to the vehicle approaching my position.
And based on the reading that you received of 58 and you were monitoring a 45 mile an hour zone, what did you do next?
At that time, when I got the 58 and 45, when I got the 58 and 45, set my LiDAR device down. I maintained visual sight of the vehicle that I got the reading from. When Mr. Page approached my patrol vehicle, so I exited the parking lot which I was sitting in.
Objection, I approached your vehicle.
All right. Can you just clarify when you say?
I never got out of my vehicle.
All right, well, let's let him clarify the answer. I took it to mean something else. So no, you have a right to make an objection. Can you just have him clarify what he means by that?
Yes, Corporal Schillenberg, can you please clarify your last statement?
So sitting on the west side of Telegraph Road, monitoring southbound traffic in a parking lot.
And that was the parking lot of Turbo Motors?
Yes.
At 12200 Telegraph?
Yes.
Okay.
So sitting stationary in that parking lot, when I got the reading of 58 and 45, Mr. Page was 694.6 feet away from my vehicle. So as he passed my vehicle in his automobile, that's when I exited the parking lot, pulled behind his vehicle, activated my emergency lights, and initiated a traffic stop on his vehicle.
All right. And that traffic stop was initiated in the parking lot down the road at 12510 South Telegraph?
Yes, that would be the Enterprise.
What was it?
Enterprise.
Enterprise, okay.
And you maintained visual contact with the vehicle the entire time? All right. Did you at some point identify the driver of that 2020 Ford Fusion, silver in color?
I did.
All right. And just for purposes of the record, do you see that individual in the courtroom here today?
I did.
And describe what he's wearing.
Wearing a brown suit and black undershirt.
Your Honor, let the record reflect that he has identified the defendant, Zachary Ryan Page, seated at counsel table.
The record shall so reflect.
Based on your reading and your observations, Corporal Schillenberg, did you then issue a citation to the defendant?
So while we were on the traffic stop, I asked Mr. Page for his identification numerous times, which he refused to do so. I refused to do so. At that time, Sergeant Kish made my location. Mr. Page eventually ended up providing his driver's license to Sergeant Kish, At that time, I was able to issue them a citation for the speeding 11:15 hour.
And when you were observing traffic on southbound Telegraph from your location at Turbo Motors, did you have were you able to maintain a clear visual of the traffic and the defendant's vehicle?
Yes.
Okay. Your Honor, I have no further questions this witness this time.
All right, Mr. Page, you have some questions for the witness? You're free to step to the podium just so the court reporter can take everything down.
No questions for the witness.
Okay. All right. You're excused, Corporal Kish. Thank you.
People rested this time, Your Honor.
All right. Do you have anything you want to enter into the record?
I want to enter into the record that I'm here today making special appearance under sue juris as one of the people of Michigan, not as a defendant under the jurisdiction of this court. I'm asserting my unalienable rights as secured by the Michigan Declaration of Rights under the United States Constitution, particularly under Article 1, Section 1 of the Michigan Constitution, which establishes all political power is inherent in the people. At that outset, I raise jurisdictional challenge to this court.
Your Honor, may I interrupt? And I apologize for interrupting, but Corporal Schellenberger is our traffic supervisor, and there's been an issue over the Taylor Police Department this morning. Technical
He's
difficulty.
He's free to go. Do you have any other questions for Corporal Schellenberg?
No.
All right, Corporal Schellenberg, you're excused.
Thank you.
All right, go ahead, sir.
This outset, I raise jurisdictional challenge to the court as jurisdiction must be proven on the record before any further proceedings can lawfully continue. The separation of powers doctrine, as outlined in Article 3, Section 2 of the U.S. Constitution and the Michigan Constitution, makes it clear that no branch of government may exercise the powers of another. Before proceeding, I require clarification on whether this court is operating in a judicial capacity or administrative. If this court is acting under administrative directives or executive branch policies, rather than operating as a constitutionally recognized judicial body, then it is exceeding its lawful authority. No administrative agency, including the SOS, possesses lawful authority to direct judicial rulings or override the people's due process rights. Any attempt to enforce such directives constitutes an unconstitutional exercise of power, rendering these proceedings null and void, ab initio. Furthermore, jurisdiction cannot be established by assumption, presumption, or coercion. Due process demands that I am provided with clear lawful authority establishing the legitimacy of this court's jurisdiction over me. An individual exercising my constitutionally protected right to travel. Without such proof, this court is proceeding without lawful authority and any ruling is issued a legal nullity. I now formally demand that this court is placed on the record the specific constitutional authority establishing jurisdiction over me as one of the people of Michigan, the legal basis that allows this court to act under administrative directives or executive policies without violating the separation of powers doctrine, proof that I was engaged in regulated commercial activity as no jurisdiction exists, absent clear evidence that I was operating as a licensee in commerce at the time of the alleged incident. Until these fundamental issues are resolved, I will not proceed under any assumption that this court has lawful jurisdiction over me. To do otherwise would be to waive my inherent rights, which I do not consent to. I stand firmly on my right to due process, equal protection, and the supremacy of constitutional law. The burden is on the prosecution and the court to establish jurisdiction before any further action can lawfully take place.
All right, thank you, sir.
You're welcome.
All right, I heard testimony today from Corporal Billy Schellenberg. Corporal Schellenberg testified he is works the traffic bureau at the city of Taylor, and that he was in that capacity, working in that capacity on November 4th of 2024 at 1:35 p.m. approximately. He testified that this occurred within the city of Taylor, within the state of Michigan. He testified that he is trained and certified to use LiDAR devices, and that the device had been inspected. He explained how the device is placed at the hood of the vehicle or aimed at the hood of the vehicle, and it determines the speed in feet from the LiDAR device. He testified that at the time, I can't recall the exact number, but he was approximately 600 feet away from the driver of the silver Ford Fusion, and that he was clocked at a speed of 58 in a 45-mile-hour zone. He testified as the vehicle came towards him and passed him, he put his device down and initiated a traffic stop. The stop ultimately occurred at 12510, which is on Telegraph Road, which is the business of Enterprise. Corporal Schillingberg also identified Mr. Page as the driver of the motor vehicle, and his license was ultimately produced, and he was issued a traffic citation. The standard for these hearings is not beyond a reasonable doubt, and there was no questions to Officer Schillingberg that offered any contradictory testimony to the testimony that was issued in this case. Therefore, Mr. Page, I find you responsible of the civil infraction of speeding 11 to 15 over, and that has a fine of $130. Mr. Page, do you need time to pay?
I do.
Okay. How much? Can you pay in 30 days?
I mean, yeah, if I got on a payment plan.
All right. Well, would you rather pay something on a monthly basis? Can you pay $70 a month, $50 a month? Tell me what you can.
50 is good.
50 a month.
Yeah.
All right, they'll send you notice of the payment plan. Are you in Hidden Lane still?
Yes.
All right, Mr. Page, you'll receive notice of that in the mail.
All right, people of the state of Michigan versus Drew James Peltola, files 24-7831 SM and file 24-7819 SM. Mr. Peltola appears from the Dickinson County Jail. Counsel at
known as Drew James Peltola appears before you as an entity.
Hold on a minute. Just let me make the appearances, and I'm going to give you the floor, okay? In regard to the matter, Nancy Schaub is here as both his counsel on the underlying file on 24-7819 SM, as well as the first bond violation. She's here as CAFA counsel on bond violation number 2 in this file, as well as a new file of 7831 SM. Kristen Cass is here on behalf of the prosecutor's office. Drew Peltola, I'm going to give you an opportunity now to say whatever you want to say. Go ahead.
Ma'am, I was trying to get a ride to court this morning. This bond violation.
Wait, sir. I don't want you to talk about the underlying charges. I wanted you to say whatever you wanted to say. I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being.
All right. Is there anything else you'd like to state for the record concerning this issue then, Mr. Peltola?
No, there's not, Your Honor. I would just like to be released again on a PR bond. You have expedition charges. I'm asking the courts to please release me on a PR bond again, and I'll continue to abide by court rules and stay off of drugs and try to maintain my court dates.
All right. In regard to the matter then, Mr. Peltola, I have an advice of rights and plea, and for the record, I will acknowledge your comments, that your objections in respect to the court's jurisdiction and whatnot are noted for the record. All right, concerning the matter, then I have some concerns regarding Mr. Peltola. He seems to be on a spiral. This started with a disorderly drunk on February 4th in a public place. I saw him on February 5th. I set his bond terms. I saw him back on February 12th, with a .236 on a preliminary breath test. I set bond at that time on the bond violation and the underlying. And the reason I told him then that I was going to give him the break is that normally I see people in between, they get arraigned, I give them the warning, and then they come back on a bond violation. He had not had the warning in between because he violated his bond so quickly that I saw him all at once. So I told Mr. Peltola at that time that I would set the bond at a 1,000 PR, but understand that if he came back again, he would leave me no opportunity or new choice. So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop, involving another bond violation, as well as a new underlying charge that I'm free to assume is true for purposes of setting bond. So for purposes of setting bond today, then, for the following reasons, and in regard to his Wisconsin matters, very serious matters, he's got 2 felonies pending in Brown County from 2023. The first one alleges possession of narcotic drugs, a felony, possession of a controlled substance on or near certain places with a modifier, carrying a concealed knife, possession of drug paraphernalia. That case has been pending through for quite some time. And he has a court date for a status conference scheduled for February 26th at 11 a.m. Then, so the date of this offense was filing date of 2/10 of 2023. He's got a filing date of March 15th of 2023 in Brown County, another felony alleging bail jumping as well as possession of drug paraphernalia. Likewise, that has a court date at the same date and the same time as the other pending felony.
I think that is part of the other pending felony. They charge it as a separate offense, but
It's a separate case. Separate total separate case, total separate charges, total separate bond, total separate court dates. This is file 23 CF 448. The first one is 23 CF 240. So in respect to the matter, my point being, for purposes of setting bond, Mr. Peltola has some substance abuse issues going on. He's got numerous cases pending in Wisconsin as well as now here. In regard to the matter, Mr. Peltola, I'm going to direct you to talk to your lawyer. I'm setting bond. Concerning the new theft case, then the conditions are going to be as follows. Mr. Peltola may not enter into the Norway Quick Stop as a condition of his release. He is not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Mr. Peltola is subject to random PBTs and drug screens. Mr. Peltola may not go in any businesses that sell alcohol for use inside, such as bars and taverns. Recreational and medicinal marijuana use and possession are prohibited until or unless further order of the court. Conditioned on him signing that waiver of extradition, which I do have in the file, I will allow him to go back and forth to Wisconsin for purposes of court hearings and or meeting with his attorney. If
in residency, he lives in Wisconsin.
in residency. No, he lives in Vulcan. Or he says Vulcan. Is that just your
Bracket.
mailing address?
Yes, we can do it like that if you choose to.
Well, where is your residency?
My residency and my domicile is 1968 River Street. We can switch it with a mailing address to W43, the apartment 13 in Vulcan, Michigan. The address should be in there. It should be bracketed.
Right, and that's apartment 13. You didn't put that on there though. Apartment 13?
Yes, ma'am.
And that's your mailing address though?
Yes, but the problem is that building's not registered anywhere. I had to go to the post office and I had something mailed and they told me that my mail was being returned and because there's no actual mailboxes in the building.
All right, so I got 2 issues I need to deal with here. One, do you live in Wisconsin? Do you have to go to Wisconsin for purposes of residency or just your court stuff?
My mailing address, my residency, and my domicile are all registered at my mother's house. There was some unexplained events that I will not say out loud.
I don't know where your mother's house is, Mr. Peltola.
River Street, Niagara, Wisconsin, 54151. My mailing address will be W45. That's the Norway or the Vulcan address. I can't remember that off the top of my head.
All right. So in regard to bond, then condition on him signing a waiver of extradition, I'll allow him to go back and forth between Michigan and Wisconsin for residency, court appearances, meetings with his attorney. In regard to the matter, if you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. Concerning the amount of the bond on the new retail fraud, I'm going to set that. I'm going to set that at 1,000 cash surety, 10%. In regard to the newest bond violation, then I'm finding for both of them, actually, I'm going to make a record based on the factors the court is required to consider under MCR 6.106, considering the frequency, the charges, the dates that I have mentioned, as well as the ongoing Wisconsin matter. I am finding that to release him on a personal recognizance bond would not adequately ensure public safety. In regard to the bond violation, concerning the matter, then I am going to set the bond violation at 2,500 cash surety, 10%. So, Mr. Peltola, those bonds are set. If you get out, you make sure to get in touch with your lawyer. If you're in custody, she'll be in touch with you. You may.
Yes. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
All right, Mr. Peltola, I'm not going to argue with you. Your sovereign citizen has been noted for the record. In regard to the matter, you are under the order of the court. You're under the jurisdiction of the court. I decline to follow what your.
Can I at least admit I was arrested on a larceny charge that was dropped through a case prefix, UN, all incoming evidence? Can I at least have you admit that in the court of law that you guys illegally kidnapped me again with a larceny through John Rod D. Clark, Norway Police Department? Can I just have you admit that once?
No, Mr. Peltola, I don't even know what you're talking about. I will not admit that. Thank you to the jail. We are off the record on this matter.
I'm not threatening you. Say one more word and that's 30 days. 30 days.